All right. Welcome everyone to our February Focus on Forms. And we are going to start this series with the listing contract that we like to use at Remax Platinum that is provided to us from the Michigan Realtors. That is their Form BB because we are a designated agency company. So that's why we use BB rather than just Form B. But that is, yeah, the listing contract from Michigan Realtors. I'm going to share my screen and then present the listing contract as we go through it. All right, so here we see it. Very important thing I want to point out, if you don't have contract dates on your contracts, then they are not valid contracts. All contracts need to have both the starting date and much more importantly, actually, is the expiration. The beginning, as we'll see, is this contract is about when you begin to have the exclusive right to sell the property. So it need not be when you're putting it on the MLS, it's when you're signing the document, the date here, it's starting the process of nobody else could come along and be that listing agent during that time. You are the only one that can sell the property during this contract period. So let's put in today's date. In an expiration, let's take 6 months out. All right, so the listing broker office, the address, designated agents. Here's one that I think throughout the company we need to get some of the teams on board with is when you have a team with multiple agents, even if they're buyer's agents or what have you, each team member needs to be explicitly identified in this designated agent portion. If there's so many team members that it can't fit on this line, then you need to add a additional page to the contract spelling out all of the agents that basically anybody where if you have a team that is taking on this listing, if there's going to be somebody that could be a potential buyer's agent, but in that capacity then be a dual agent because they're on your team, they need to be listed here as a designated agent. And what's nice is at least in SkySlope, it's easy to add additional members to it. Just go down here, add another. So, and so it just, you can keep adding more and more designated agents. You have the email address for yourself, supervisory broker. So it's likely to be whoever your managing broker is. So Rob down in Ann Arbor, myself in Fenton, Nicole out of Brighton. So I'm going to say Joseph DeKrug. No, since shouldn't be my own supervisory broker. And anybody could choose to have Joe, since he is our broker. You could have him in there as well. So the sellers, it's important you have to have the name of the sellers, all sellers that are on title to the property. As far as the addresses and emails and phone numbers, those are not required, but it's a good opportunity to collect that information from your clients by having it here. So then if they, if you're telling them, hey, I'm trying to fill out the listing contract, could I get your email for each seller and phone number as well? All right, but let's dive into the actual text. So the goal of this class is to be able to know what every paragraph in the listing contract says, because if your clients have a question, you need to be aware of what the answer is. So in consideration of the agreement of brokerage firm to market seller's the property, and to use its best efforts to find a buyer, seller gives brokerage firm the exclusive right to offer for sale and to sell the property for the listing period stated above. So the exclusive right to offer for sale and the exclusive right to sell the property during the contract period listed up here. So what that means is we have the exclusive right to sell. That is different from exclusive agency. When we're filling out our listings for the MLS, we often have to check, is it exclusive right to sell or exclusive agency? It's exclusive right to sell. And this contract has that as the default because we want it to be that way. Exclusive agency as the alternative. What that allows for is a situation where the seller could go out and find a buyer and sell it themselves without owing our brokerage a commission. We don't want to allow that. We want it to be that, and this contract later states that they'll forward along to us any prospective buyers. But that's the whole point, is that we are the only ones that can act to help facilitate and sell this property in an agency capacity. So in consideration for the exclusive sale rights, brokerage firm agrees to use reasonable efforts to sell the property, to present the property to other realtor companies through an MLS, and to engage in marketing efforts to expose the property. So this does explicitly state that we will be putting the listing on the MLS. So that's another thing to note, that if you were just looking to do a pocket listing forever, in theory, we would not be upholding our end of this agreement because we are stating that we will be putting it on the MLS at some point. Brokerage firm and seller hereby designate the agents listed above as the seller's designated agent. Seller shall have an agency relationship with only the brokerage firm, designated agent, and supervisory broker named above. So this is an exclusive relationship where they are unable to hire and form agency with another brokerage for selling their property. Then we get into the details of the property itself. It's important to note that you need at least either the legal description or the property tax ID to be on this contract, because street address alone is not sufficient for identifying the property for this contract. You need to have either the legal description or the property tax ID, or ideally both. All right, so then you get into the boilerplate text of all the stuff that is by default included in the sale. And so then it's referring to all the fixtures, and obviously, yeah, the gas, oil, and mineral rights. But then you get into like the built-in appliances, the lighting, the mirrors, all of the things that then the purchase agreement is likely to also have very similar boilerplate. But it's important to know what's in this section, because it's like, okay, so the attached TV mounting brackets. Sometimes there's a question later on. Now, the purchase agreement is going to be the final arbiter as to what is included in the transaction. But what's important to know is we are crafting a listing contract that is creating an initial offer to the public, where we are creating an offer that a buyer could come along and say, hey, I accept. Here's a cash offer, all your terms that you laid out here, no contingencies. We're good to go. I'm ready to buy it. And so if that buyer comes along and does that and says, hey, full price cash offer, no contingencies, they are accepting the offer that we're putting out there. And so then our seller is bound to it. So our listing agreement needs to include all of the details as to what that initial offer to the public looks like that a buyer could come along and accept. That's why it lists out all of these fixtures, because then it's clear what we're offering up front. So the TV brackets, attached mirrors, all the normal stuff. But down here is where you could decide to exclude, just as you would in a purchase agreement. You could say, okay, let's exclude the chandelier in the dining room or the mirror in the primary bathroom. Any of the stuff that is in the boilerplate that you don't want that the sellers explicitly don't want in their initial offer to the public, you need to explicitly exclude it here in this section. This section above, though, is where you would put the appliances that aren't built in, such as the refrigerator and the microwave and all the normal appliances that we're adding as part of the listing. Right, so now down to year built. Having the seller identify if it was built in 1978 or later. If they, then you can check this box, say the year built, make sure it's the seller telling you when it was built. Because then it's the seller representing that the year built was after 1978, and so then they don't need the full lead-based paint disclosure form. It can instead be just the single paragraph one that they end up initialing or signing. So let's say 2003. All right, and let's say up here, I'm going to put in the refrigerator and exclude dining room chandelier. Okay, so now price and terms. So this is again the price that we are offering to the public. So if the public were to come along and somebody were to give us this amount as an offer with no contingencies, it's the seller then being obligated to accept that, where, okay, they've bound themselves because they've put it out there and listed it at this price. And this is where you could add additional conditions that, okay, subject to the sellers finding the home that they want to purchase within 30 days, giving your sellers a clause within it that doesn't make it where they are bound if somebody comes along with that full price cash offer. You could do that in this little section here. That's just something to be aware of. But obviously, yeah, this is where you would put any of the unusual things that are not in the later sections, like possession and stuff that we'll already get to. And then it also says, the brokerage firm authorized to sell for that amount or at such other price and on such other terms and conditions as sellers may agree to in writing. So if you receive an offer that isn't for this amount, that's totally fine too. We're able to sell the property if the sellers agree to that other offer in writing. It's not like we can only sell it for this amount. Okay, on to number 5, where it gets into the commission and compensation. Obviously, it has the new language that's required from the settlement. Brokerage firm's fee for services rendered is not set by law and is fully negotiable, which is true. It's up to you to negotiate with your client what the commission is going to be and how you want to structure it. So if during the term of this listing, anyone produces a buyer who is ready, willing, and able to purchase the property at the listed price and terms, so that's why, if somebody comes along, we list it with all of our details, and somebody comes along and says, I accept full price cash offer, no contingencies. At that moment, we've done our job. We produced a buyer ready, willing, and able, and in theory, then yes, the sellers are obligated to pay our commission. Or for any other price, terms, or exchange to which seller consents in writing. So again, if the seller accepts a purchase agreement and that, there's for a buyer who's ready, willing, and able. So now if that changes later where the buyer decides they're not willing or not able or not ready, then the seller's out of the, no longer obligated to purchase or to pay the commission. But if it's the seller that doesn't want to proceed, even though the buyer is ready, willing, and able to move forward with the purchase agreement that the seller has signed, then yes, the compensation is still owed, the commission is still owed. Seller agrees to pay brokerage firm a fee equal to $4.95. You can obviously go higher than that if you want to keep the extra. And a commission equal to, here's where we get to decide, okay, what is the total listing commission that, and are we building into that an amount we're going to offer out to the other side? So let's say we're doing it at 5.5%. Further, if within, okay, so this is the protection period. So we're going to say 6 months. I used, I got into this with the standard being 180-day protection period, 6 months. You may do 3 months, you may do a different amount. What this protection period is, though, is the number of months after the expiration of the agreement. So after this expiration date up here, that if the seller sells, trades, or exchanges the property to anyone introduced to the property during the listing term, then the stated compensation will be paid by the seller to the brokerage firm, unless at the time of sale the property is listed with another realtor company. So what this means is that if you have a listing and you're getting showings, but it doesn't sell, and then it expires, if the seller then sells subsequently to one of the people who saw the property during the listing period before it expired, if the seller doesn't hire another agent to relist the property, but instead just, goes on without another agent, but sells the property to a buyer who saw it while you had it listed, then the protection period means that they still owe us a commission, because that is, they'd be selling it to someone introduced to the property during the listing term. Now, if you unconditionally withdraw the listing, then you are voiding your protection period. Once you've given them an unconditional withdrawal, you've released them from any obligation in this listing contract. So I know with my deals, I have had it where listings were coming up for expiration, and I gave them the unconditional withdrawal because I didn't want them to be bombarded with agents reaching out to them if their listing expired instead. And so it was like, okay, I'll unconditional withdraw, knowing then that I am not protected, where if they turn around and sell it to somebody who had just seen it last week while it was still listed with me, then I'm out of commission. I've given them that release, which may not be advisable. But so if you allow it to expire and they don't relist it, the most likely scenario in which this would come into play is you receive an offer and it doesn't, during negotiations, falls through, doesn't actually work out. And so then the listing expires and the seller reaches out to that buyer who wrote an offer while you had it listed, and they then try to cut you out of it. That is why, that is a clear case example and most likely situation in which this would matter, because, hey, clearly you can prove that the buyer was introduced to the property during the inspection or during the listing period. And so, it's still during that protection afterwards. Yeah, and sale, also the concept of sale includes options and things like that. All right, in the event of litigation involving the compensation, if we have to pursue our commission, then and we prevail, then the seller is also responsible for our attorney's fees. So number 6 here is where it gets interesting, because again, this is about, we are putting out an offer to the public, and with our offer to the public, that includes the purchase price. How much do we want to offer to the agent representing the buyer. Now, in Remax Platinum, we don't do sub-agency. We do not recommend that our agents allow somebody who brings in the buyer to serve as a sub-agent to our seller. So we don't put anything here. Likewise, we don't view transaction coordinating as really something that is often able to be held up in court is what somebody is acting as. In reality, they're almost always an agent, and so we don't recommend offering anything for transaction coordinating. What we recommend is item number B, option number B, or option number D. So you have built, or you have your total commission, let's say 5.5% here, and I'm going to offer out 2.5%. So keep in mind though, this is what I am offering, or the seller is offering to the brokerage firm producing the buyer. It's a 2.5%, which is a portion of this 5.5%. So then it means that the listing side, the listing brokerage, we retain 3%. But this is just an offer. The actual terms of what is being provided to the brokerage that brings the buyer, that's going to be spelled out in the purchase agreement itself, either through a compensation agreement between the brokers or a buyer-broker compensation addendum or language in the purchase agreement. Now, to cover D real quickly here. So we could have it be that we're listing, let's say even at the 5.5%, but we're not upfront offering anything to that broker bringing in the buyer. It's instead, we tell people who inquire, we tell agents that inquire that, it'll be it's a negotiable term that's part of the purchase agreement. And we're not offering anything. That could be fine, and you just have the seller's initial D, but if you are offering, you have an initial B. But then let's say, okay, offer comes in and the purchase agreement has 3% going to the buyer's broker. What's very important to make note of is, where does that 3% come from? If it's the compensation agreement between brokers, meaning you as the agent or your managing broker needs to sign the form, and it spells out that 3% will be paid to the buyer broker from the listing broker, then that 3% is being deducted from here regardless, so it would come from the 5.5% regardless of what we were offering out. And so then we would be left on the listing side with 2.5% if it was a broker-to-broker compensation agreement. If, on the other hand, though, it's a buyer-broker compensation addendum or language in the purchase agreement that says the seller shall be paying 3% to the buyer broker, and we, as the listing brokerage, do not sign anything, we are not a party to the purchase, to that document, then that does not override this 5.5% listing commission that we have built into the contract here. We are still then obligated to offer to the buyer broker 2.5 that we've built in. But the other 0.5% is coming from the seller because the seller has agreed to it as part of the terms of the purchase agreement, just as if the purchase price was less than the list price and the seller agreed to it. If it's the seller signing that the amount going to the buyer broker is more than what we were initially offering, then this listing agreement does not need to be amended in order for us to retain our commission. I hope that makes sense. So we list at 5.5. Offer comes in asking for 3, even though we were only offering 2.5. If it's the seller agreeing to that 3% and signing it, then we still keep our 3% and the total commission is 6. If it's that the offer includes a broker to broker compensation addendum asking for 3, we've given away 3 from the 5.5% total, and so we're only left with 2.5. Unless you then amend the listing contract. All right, number 7 here. I personally think number 7 does not need to be part of this. And I'll show you why. But yeah, in theory, we're putting an offer out to the public that somebody in the general public could come along and say, I accept. So in addition to the compensation offered above regarding commission, seller does or does not authorize RE/MAX Platinum to advise potential buyers and their agents that seller may be willing to consider seller concessions. So the may be willing section here, part here, is why I think that this is kind of pointless. Because it's like writing a purchase agreement where it says, buyer and seller agree that seller may contribute 3% towards the purchase price. It's like, well, that may makes it kind of meaningless. It's not a shall. But regardless, it's in our listing contract, so we need to know how to handle this paragraph. So what I do is I tell my sellers, okay, if somebody were to ask, hey, I'm working with a FHA buyer, they're going to need seller concessions. Is that something the seller is open to? Yeah. I don't think we need to upfront tell people, oh, we're, summarily rejecting the concept of seller concessions to assist buyers in obtaining the property. No, I mean, we're open to that. That's all we're agreeing to at this point, is open to the idea if the rest of the terms are agreeable. Because it says this invitation is contingent upon all other terms of the offer being acceptable to the seller in their sole discretion. But then there's the question of this invitation for additional seller concessions shall or shall not be disclosed in the MLS. So 9 times out of 10, you're checking they're open to the idea, but I'm not putting it in the public remarks like, hey, seller concessions are expected at this list price. Where you may do the shall is if it was like, okay, we're going to offer a carpet allowance or that sort of thing, and you want to put it in the remarks that there is some sort of seller concession being included and part of the marketing purposes, then it would be a shall. But it should almost always be does, unless the seller, for some reason, just hates the idea of seller concessions and refuses to even look at offers that has them. And then it will almost always be shall not be disclosed. Participating in the MLS, we're authorized to submit this listing to any multiple listing service or other medium selected by us and provide any such MLS service with a copy of this agreement, any changes to the agreement, and post-closing information, including the sales price. So after it closes, we let the MLS know what it closes for, any information about that transaction, where then they can report it publicly. Title. So the seller is agreeing that they can provide good and marketable title, and they will execute and deliver a warranty deed, land contract, or other instruments that are required. By agreement on a subsequent purchase agreement, seller will provide at seller's cost an owner's title policy in the amount of the purchase price. So just as any purchase agreement needs to clarify who's paying for the owner's title policy and all those things. If we're creating an offer to the public with this listing, this title section is here to make it clear that yes, seller is agreeing to the obligations of conveying title, including providing the title insurance policy. Default. So now here is if the seller refuses, if they accept an offer but then refuse to perform, then the total agreed upon compensation shall be due and payable upon such refusal. So going back to section number 5, yeah, if the seller defaults on a purchase agreement, then they still owe everything in 5. But if the purchaser defaults on a purchase agreement, and so their EMD is sacrificed, then the seller is agreeing that the EMD shall be applied first to reimburse the listing agent for all expenses incurred, and then the remainder, of the remaining money from the EMD, how much shall be going to the agent, how much goes to the seller. I almost always have it as 0%, because if the buyer is sacrificing their $5,000 earnest money deposit, I am expecting that $5,000 to go to the seller. I'm not personally trying to take 50% or 20%, whatever it may be, but there are some agents who do expect a percentage of the EMD. It's up to you to decide how to handle that. Our previous listing agreement that we used to use had the default boilerplate language be 50-50. So in theory, any EMDs that the buyers were sacrificing to the sellers, in theory, the agents were entitled to half that EMD. But I just, for PR purposes with our clients, yeah, 0% is what we keep. Marketing. Brokerage firm may photograph the property and then advertise it, and the seller acknowledges that advertising in this way makes it publicly known certain aspects of their home, like the contents inside and the layout and things like that. And that we don't control, once we put the photos out there, we don't have total control as to all of the different sites it may get to. And this is important because, yeah, they're then, by signing this agreement, they're giving us the ability to take those photographs and put those photographs out there, because it then gets into liability that we'll see later on. Lockbox access. The seller authorizes a lockbox to be placed on the property in order to permit showings by real estate licensees and to enable service providers to perform services in conjunction with a proposed sale of the property. So they're giving us permission to put a lockbox on the home, so that way then, we and other authorized people can access it. Brokerage. Okay, so the release. Brokerage firm is not responsible for the security of the property. Just as the marketing language is here in part for this purpose, that if in marketing it, we show that there's a really nice TV. If then somebody, breaks into the property and steals the TV, well, we're not liable for showing that there was a nice TV because they gave us permission. And then we're also not going to be responsible for the security of the property itself. Seller releases and holds harmless Remax Platinum and its agents and cooperating agents from any and all liability as a result of damage to the property or damage to or loss of any personal property located within the property occurring during any showing. So if during a showing, a potential buyer knocks over a vase and it breaks, we are not responsible. Whoever does the actual damage is responsible, but we are not, just because we had it listed and the damage occurred during a showing. So the release is about damage to the property itself, and it protects us and our liability, that we're not responsible for things that we did not do. All right, inquiries. Because we have the exclusive right to sell, not just exclusive agency, then seller agrees to refer to brokerage firm all inquiries received concerning the property during the period of this agreement. So if the listing sign goes up, neighbor walks over, tells the seller, hey, my mother would love to buy your house, then the seller in this contract is agreeing up front to pass that neighbor's mother's information along to us, rather than trying to work directly with the neighbor's mother. We are the ones that have the exclusive right to sell the property, and not just as, exclusive agency. So they need to pass along that potential buyer to us. Additional offers. This is a important one because, yeah, once you have a binding purchase agreement in place, then the seller is acknowledging here that if you receive other offers later on after you're binding to one, you may not pass those offers on to the seller. So maybe they signed, accepted an offer for $1 million on Monday, but then on Wednesday another offer came in for 1.5 million. Well, yeah, you're not telling the seller about that 1.5 million offer. Um, you have the option, in my view, even though it says shall not present, you shouldn't present it in full, but you have the option to let them know about it, especially because if the buyer number one starts to try to renegotiate or waiver on, whether or not they're moving forward, then yeah, it's beneficial to the seller to know of that additional offer that came in with stronger terms, so then they can use that information when deciding whether or not to renegotiate with the first buyer at all. But because the seller doesn't have the option to just unilaterally cancel the purchase agreement with buyer number one, that's why you shouldn't really tell them about buyer number two's offer, um, because it may just create certain headaches that you don't want to create when there's no benefit to the seller to have that information provided to them in full. So yeah, just be aware that you're not obligated to present additional offers once a home is pending. All right, professional advice. We stay in our lane. Seller acknowledges and understands that the brokerage firm, its agents, employees, and representatives are not acting as appraisers, builders, accountants, engineers, environmentalists, inspectors, surveyors, tax advisors, or attorneys in the context of this agreement or any future purchase agreement. We are real estate professionals. I am not a tax professional, and likely you are not either, and we should not represent ourselves as such. We should only represent our expertise in real estate. And so then this is the seller acknowledging that that is all they are looking to us as, is real estate experts and not their inspector. Seller has been specifically advised to seek professional input or advice in these areas from those professionals as may be advisable and prudent. FERPTA, if the seller is a foreign entity, then this is saying that the seller shall provide an affidavit of non-foreign status and otherwise comply with the withholding provisions from FERPTA laws. Possession. So just as if you were writing an offer to purchase represented buyer, well, this also needs to have some possession aspect to it if we're putting an offer out there to the general public that they could say accept. It's very common for people to just write negotiable in here. The problem with that in theory is that negotiable is squishy. And so that's not a solid offer to the public, because if you were to write an offer as a buyer's agent and in the possession area just wrote negotiable, well, you still then don't have a full meeting of the minds on what the details of that offer are. So I advise you against writing negotiable, and instead going with the upper limit of what is the most that they would want. Because then if somebody were to come along and say, hey, I accept cash offer, no contingencies at all the terms that you want, what is the term here for possession that is the furthest out that you would want? So let's say 60 days. And you could just always say 60 days. It doesn't really matter, even if then in the MLS, if they want you to say negotiable, you can say negotiable, but it's here on the listing contract. I think it's safe to, put that. Or you can say like at closing, if they're telling you, oh, it's vacant, don't need any possession. All right, heirs. So if the sellers were to die, the listing contract is still binding on their heirs and personal representatives and executors and all that. So death does not void this contract. Non-discrimination. We abide by fair housing laws and we do not discriminate, and we then tell our sellers not to discriminate. When it comes to the letters of introduction, or love letters as they're known, um, this is where I always check the box saying I will not forward love letters on to my sellers. And I tell them that I'm checking this box. If we receive offers and any of them contain love letters, I am not going to forward those on to you, because I don't want you taking on the liability that is created when you receive a love letter. Because no matter what the outcome, there is a chance of um, them, like, other of a fair housing claim arising as a result of that love letter. If you receive multiple offers and you accept the offer with a love letter, then you're opening yourself up to fair housing claims from all those other offers that you didn't accept. If you don't accept the offer that has a love letter, then you open yourself up to claims of fair housing violations from those people whose offer you didn't accept, because they could claim something in the love letter you then discriminated against them. I think it's just, personally, I don't like love letters being provided to my sellers. Um, but I mean, then if we get to the closing table and the offer had a love letter, at that point I may give it to him, because at that point there's no more decisions to be made that could be influenced by the love letter. So that's by checking this box in the listing contract and then never sending them a love letter, it's the safest route to avoid getting tied into a fair housing claim. All right, showing property and conflict of interest. This whole section here, number 22, this one actually is kind of important to really know, because this has to do with dual agency. So, seller understands and agrees that as part of marketing the property, designated agent, us, will show potential buyers properties other than the seller's property and provide such buyers with information on selling prices in the area. So yeah, we are not exclusively showing their home. We're showing their home and maybe other homes and other listings as well to buyers. Seller also understands and agrees that designated agent can show seller's property to and obtain offers from all prospective buyers, including buyers with whom Remax Platinum has an agency relationship. So yeah, so we can show the listing, um, and we can receive offers from any buyers out there. If a potential buyer is represented by, this is where capitalization matters. If potential buyer is represented by a lowercase designated agent within the brokerage firm, so a different agent at Remax Platinum, lowercase designated agent. So if you're, a Fenton Remax Platinum agent, then one of your fellow Remax Platinum agents that aren't you, or a Brighton Remax Platinum, or whoever from one of the other offices. So a designated agent within the brokerage firm other than capital designated agent, you and or anybody that's signed, that's listed up here in the designated agents section above. Then in that situation, the brokerage firm, Remax Platinum, and the supervisory broker, Joe DeKrube, shall automatically be deemed disclosed consensual dual agents. So we have a listing, and Rob down in Ann Arbor shows my listing, and In so doing, he's not a designated agent, capitalized designated agent listed in this contract, but he is a designated agent at Remax Platinum. He is then showing that my listing, and the broker at that point, and the Remax Platinum as a firm, is a consensual dual agent. The sellers are allowing Remax Platinum to be as a brokerage, a dual agent there. But Rob can maintain his status as a buyer's agent, and me as the listing agent can maintain my status as a listing agent because he's lowercase designated agent and not listed above. But if, on the other hand, the particular buyer is represented by myself, capital designated agent, then at that point, I need to decide which of these following occur. So, all right, if I bring a buyer to my own listing, then I shall notify both the buyer and the seller that either A, I am a that my designated agency shall terminate the relationship with the buyer as it relates to this property only. So either I show my listing to a client and I am no longer their buyer's agent for just that house, just that listing that I'm the listing agent on, or I am a dual agent representing both the seller and the buyer during that showing. And the reason all of this dual agency stuff is important here in the listing contract is because agency is created before offers are written. So later on, yes, if I end up writing an offer for that buyer, I'm going to need a dual agency consent addendum and things like that. But this listing agreement and this section here allows me to act as a dual agent during the showing itself. Or if I were to check this box, then at the time of the showing, I'm only representing the seller and not the buyer. I may show the buyer 10 houses and one of them is my listing. So at 9 of them, I'm their buyer's agent. I'm giving them all sorts of advice and doing all the things that a good buyer's agent should. But when we get to my listing, if I have this box checked, then I have to instead only say the things that are in the seller's best interest because I'm representing the seller only. Now, what's important is you're going to have a buyer contract as well. Your buyer contract should align with your listing contracts. However you do this section here should be consistent across the board for your listings and buyer contracts. Because that buyer contract is going to also reference, hey, if you end up showing your buyer one of your own listings, what is happening? You don't want one to say you're going to be acting as a dual consented dual agent during the showing, but then your listing contract have this one where you're saying you're only representing the seller. You want to make sure that you're consistent across the board, and that's why I personally recommend doing the dual agency one. Because then, yeah, during the showing, you're a dual agent. And then on your buyer contracts, you do the same, that you're just acting as a dual agent if you're showing your own listing. This one down here, designated agent shall act as a transaction coordinator. We do not do transaction coordinating at Remax Platinum, so do not check that one. Hopefully that all makes sense. All right. In all cases, brokerage firm shall be entitled to the total compensation provided herein. So going back up to number 5. So the total compensation there is what the brokerage firm gets if we're dual agency, unless otherwise stated. All right, but here's an interesting thing. So designated agent will preserve any confidential information obtained during another agency relationship or in a prior or pending transaction or business relationship. Seller acknowledges and agrees that the preservation of this confidential information shall not constitute a breach of any fiduciary duty owed by the designated agent to the seller. So, as listing agents, we owe a fiduciary duty to our sellers to tell them everything we can that would benefit them. But let's say you were working with a buyer and you had them under contract, you're their agent, they're providing you confidential information. They end up deciding they don't want to work with you anymore. They go out and get another agent. That agent then shows your listing and writes an offer. You obtain confidential information about the buyer when you were an agent for them. You cannot provide that confidential information to the seller. This is where the seller is acknowledging that even though you have a fiduciary duty to tell them everything, well, here's one exception. You cannot pass on confidential information that you had acquired while you're an agent for somebody else. Indemnification, very similar to the release. Up here, the release, number 13, deals with the property. Indemnification deals more with personal bodily injury. Seller shall indemnify and hold harmless brokerage firm and agents, cooperating brokers from any liability for any reason as a result of injury to persons or damage or loss to property arising out of the showing of the property, but including but not limited to reasonable attorney fees and costs. So yeah, further protections for us. Representations. Seller hereby acknowledges that brokerage firm is relying upon the representations, whether oral or written, made by seller with respect to the property. If the seller tells us up here that the home was built in 2003, we then can rely on that and tell others that it was built in 2003. If the seller was lying and it was built in 1960, we are not responsible because the seller is telling us and we are then relying on, and the seller is agreeing for us to go out and tell others. So yeah, the seller warrants to us that any representations the seller has made or shall hereafter make are true, and we are authorized to make such representations to prospective buyers. We can only, tell buyers what the sellers tell us as far as we are not, it is not our obligation to go out and verify all of the things. If the seller says that they installed the pool in 2006, we're not going to go back and do the digging and find the records for when that pool was installed. We're just going to tell people, hey, they put the pool in 2006. Unplatted lands. And I default to all, but it's not likely to come into play, unless it's very specific situations. All right, seller's disclosure. Seller agrees to provide the buyer a seller's disclosure statement, as required by law, unless there's one of the exemptions. Seller agrees to indemnify and hold harmless us and our agents from any liability arising as a result of them either not filling it out or not filling it out properly. We are not responsible for what they put on the seller's disclosure statement. Home surveillance. This is a fun one because we need to tell our sellers that while video recording is typically allowed in properties, Michigan, when it comes to audio recording, if they have any audio recording surveillance devices, that is likely to violate the law because we are a one-party state where you're not allowed to record conversations that you are not a party to, where the people being recorded did not consent to being recorded. So, this is them in the listing agreement understanding that use of an audio surveillance may violate the law. So we're telling them, hey, if you get in trouble, we're warning you up front. Don't do that. Limitation, seller and brokerage firm agree that any and all claims for any lawsuits need to occur within 6 months after the date of termination. So, can't come back 2 years later and try to sue us. And likewise, we can't sue them 2 years later. So, it's regardless of statute limitations, we're building in our own constraint on that. Electronic communications are viewed as things in writing, and then they're deemed to be delivered at the time they're sent. And then electronic signatures are also valid and binding. Merger, so this agreement constitutes the entire agreement between the parties. So if there were any previously signed contracts or whatever, this supersedes it all, becomes the entirety of the agreement, because it's been merged and integrated into this one. Signatories and counterparts, the undersigned represents that all parties in title are a signatory on this agreement, and it may be signed in any number of counterparts. So if we have 8 sellers, owners, we can get them all to sign contracts, even if they're not all signing the same exact contract, as long as that contract is exactly the same, each copy, then 8 different contracts with 8 different signatures, but all the same contract can be, merged. And that is it. Well, cancellation, this agreement can be canceled or revoked only by mutual consent. So the sellers cannot unilaterally cancel this agreement. Um, and so yeah, you have to, both agree. And then the seller has read and acknowledges receipt of a completed copy. So Rob, see that you're on. Is there anything you think I should clarify for any of this?
No, I would clarify though, like you just talked about it in the cancellation. Knowing the contracts is important because in some of the other contracts, we discovered that the cancellation can be revoked by either party at any time. And so that means that the seller, whenever they want, could cancel it, and then the buyer, whenever they want, could cancel it. And it's written right in to some of the contracts that I've seen floating around. So that's why knowing the contract that you're going to use, the way Jordan is going through it, it's super important. If you didn't know that cancellation was in there, and then all of a sudden the seller's like, "I'm out.
Well,
Contract says
yeah,
I can be out." Like, what? Don't
because
be
the
taken
idea,
surprised by your own contract.
yeah, if they can cancel it, then yeah, you receive an offer, cash offer they want to accept. They cancel the listing agreement. They've canceled their obligation to pay a commission,
Right.
and they accept that offer and cut you out of it completely. And that's why, a mutual release or unconditional withdrawal of a listing is a cancellation of the contract. And that is why, as soon as you unconditionally withdraw, you lose all your protections for commission. Um,
Jordan got me this lantern. This is how I navigate contracts now. All right.
well,
No, I
cool.
it's very like you said, I think so many agents don't pay attention to what these contracts say until you're sitting in Zoom court over what this contract says.
Right.
And it's very important to try to avoid that as much as possible.
Well, yeah, and just as far as when there's the couple spots along the way, understanding what those decision points are. So you get to the part where it's, the default and okay, what number do you put in as a percentage and what does that percentage mean? It means, yeah, how much of the EMD are you keeping as an
Right.
agent if the buyer sacrifices it? So I like 0, but whatever the number is, you need to know why you're putting that number in there.
Hmm.
Because yeah, if you get a question, why'd you check this box about, being a dual agent rather than the one above it about, only like to not be a buyer's agent on that property only. I want you to only represent me, and so you can then explain to them, well, my buyer contracts, I have very similar language and I have to check the box. And so I'm telling them if I'm in that situation, I'm going to be a dual agent during the showing. I need to tell you up front that yes, during the showing, I'm a dual agent. Once an offer is written, we're going to more formally, make it clear that for this whole transaction, I am one. But I need to know before I step foot in the door with those buyers. That's why this box is checked.
Well,
So
we had this happen to us where a buyer was sent a contract. They quite obviously ran it through ChatGPT and then came back with a bunch of questions for their realtor. And it was that simple for them to question the contract. They're like, "Yeah, that's right. I don't know what any of this means." And chat tells me I need to get clarification on this. If you can't answer those questions,
yeah,
that leaves you in a tough spot where just a simple prompt is a little smarter than you. So again, knowing the contracts is important.
yeah. So yeah, so this is the first of this February focus on forums. Next week we are going to be doing the buyer contract, Form JJ, also from the Michigan Realtors. The week after that, we're going to be doing our brand new purchase agreement, which is super exciting because to have an internal purchase agreement that is now fully going to be fully updated with all the new language that is needed for FinCEN and everything that has changed over time. Going through that, that's going to be a really deep dive. And then the following week, the fourth week, we're going to get into the additional forms like the agency disclosure form and our affiliated business form, the forms that we're going to have in every file, and then some that may only be in some files. But it's like, let's get to each of these forms to be able to be as confident as possible when explaining to our clients what they are as we are asking them to sign them. So,
It's really
Sweet.
appreciated. I actually do have two quick questions before we go, if that's
absolutely.
cool.
Yes.
So similar to what Rob mentioned, every contract is going to have a little bit of a different look to it, have some different verbiage. If we're still rolling out the Remax branded contracts, should we expect something similar for the Michigan Realtor listing contract to our new
So,
Remax one?
so
Or are we not
our
doing that?
So the when it comes to incorporating our branding into the contracts, that's just slapping the brand up at the top, but we're not changing the form, so because we may decide to no longer use the Michigan Realtor form for BB or JJ, but when it comes to just updating the branding on it, that's just about getting our logo up at the top. So that way then when you're sending it to your clients, it looks professional, and they recognize it's coming from Remax, and not just the form they could print off themselves, basically.
Yeah, just want to make sure all the information today would still apply with that same contract. And
Yeah,
then
yeah.
one question regarding surveillance. So we know that you can't do the audio. We know that video's technically okay. Where do we stand on ring cameras? I know they are on the exterior of the property. They record most of the sometimes audio and video. What should we be telling both our clients that we list with and our clients that we help buy?
So the whole point of the language in the listing agreement is to protect us because we're telling the sellers, hey, any surveillance that they're doing, we are not representing it as totally legal. So a ring camera, they're
Technically, I mean, Jordan,
ubiquitous.
yeah,
Hmm?
say it the right way. Technically, the person, the homeowner, is not party to that conversation. And if they're not party to that conversation, they cannot record that conversation without consent. So you should tell them that if there's a way to turn off the audio recording while their house is being shown, they need to do that. Whether they
Yes.
do that or not, that's on them.
Right, because if they hear something and then the buyer writes an offer and somehow the buyer finds out that we're using the information that the sellers overheard from an audio surveillance in negotiations against the buyers, and then they claim that the sellers broke the law. All the language in the listing contract is trying to do is protect us to say, hey, we told the sellers that their surveillance may not comply with the law. If it does or doesn't is not for us to fully decide. We're telling them they're taking on the risk. If they do any surveillance at all, they're taking on that liability risk, the legal risk, if somebody were to try to say they broke the law.
Thanks for clarifying. That was really helpful, both of you. Thanks.
Yeah, appreciate you hopping on. You're the only agent to have done so. But yeah, so then we will do it again all next Monday at 4 o'clock and hope to see you then.
Awesome. Thanks, guys.
Bye.